Thank you very much. It's a pleasure to be back this year. Sorry we're not doing it in person, but I thought that was a great talk from Chris and did a lot of great ground laying. So I'll try and pick it up from there. By mentioning some of the really cool stuff that AI is doing now. And as you heard, it isn't necessarily that some of this stuff is necessarily new. We've had AI making creative and inventive stuff in whole or in part for a long time. It just wasn't very good at it. But really, this year, we've seen a major breakthrough in things like text-to-image generators and their commercial usefulness. So here's a cover of a popular US magazine that the magazine said is AI generated and only took 20 seconds to make. It was a little misleading because people had to give it prompts and spent a while with that. But an AI made this, and now it's on a magazine cover. And last year, an AI could have made a cover. It just wouldn't have been quite as interesting. Not just AI creating new, traditionally creative works, but also doing inventive stuff. You heard a bit about this. This is a still shot from a video made by a team at Google describing how they built a AI based on machine learning that could automate chip floor planning. And chip floor planning is the process by which someone arranges components on a microchip. And that affects how the microchip function, from how much electricity it uses to how quickly it performs. So those designs have a lot of value to companies like Intel that build microchips. And the team at Google said, well, it takes a team of people months to do this. It takes our AI less than 6 hours. And not only that, but on all the key performance indicators on how you would want a chip to function, the AI design chips outperformed the human design chips. So without this necessarily being an example of an inventive AI, it is an example of AI doing more in research and development. And when we think about things like autonomy, and Chris gave, I thought, a very helpful overview of the AI definitions, I take a more specific view of AI as really any technology that is, behaving as though it has cognition. Sometimes these are very simple programs, sometimes they're complex ones, sometimes they're based on rules very clearly made by people, sometimes they're based on machine learning. But the basic concept is you have a machine that is behaving the way that a person might behave. And it's not autonomous in the sense that a self-driving car woke up one morning and decided to start designing chip floor plans, right? It is very much a tool in the sense that it is built by people and it does what people tell it to do. But many of these systems are autonomous in the sense of completing specific tasks. So once you set up an AI like this, it just starts making chip floor plans. The people designing the system themselves may have really very little idea how to make chip floor plans. Or if you think about, for example, Deep Blue beating Garry Kasparov at chess, a group of people built that who couldn't have possibly beat Garry Kasparov, even if they were playing as a team. So AI can be both a tool and autonomous. And for our purposes, that has all sorts of interesting intellectual property implications. The industrial strategy implications of this have not been lost on jurisdictions around the world, which are constantly competing at putting out kind of cool-looking industrial strategy plans to become AI superpowers. This was the UK's most recent one, and you can see, based on the graphic, that they mean business. Not just reports, though. The White House last month put out an AI Bill of Rights. These are non-binding criteria that they would like companies to follow, companies using and developing AI, things like having AI be fair and transparent and explainable and so forth. But not all just reports and guidances. The European Commission, of course, came out last year with draft AI regulations. These don't have much to do with AI and IP, but they do create the first major jurisdiction. Singapore was the first to come up with regulations specifically targeting AI use and development, outright prohibiting some uses of AI, subjecting other uses to an almost medical device-like compliance regime, and having a lower tier of obligations for less risky uses. But of course, there are plenty of AI and IP implications. It's become fashionable for IP offices to start looking into this. The most recent wave was USPTO putting out 2 requests for comment in 2019, I think, followed by a report saying not too much needed to change. The UK IPO did one the following year and said, well, actually, we think there's a number of things that are potentially problematic here, or at least significant challenges. They did a second consultation that wrapped up this year that focused on just three things: text and data mining exceptions to copyright infringement. And the UK IPO recommended that the UK adopt a very broad one as opposed to the European Union, which has a relatively narrow one. AI-generated inventions and patentability, and AI-generated works and copyright protection, both of which we'll come to shortly. And of course, because we live in a global trade-based society, particularly in the case of intellectual property that often easily crosses borders, there's important international implications to this. If you are training your AI on people's copywritten images, and that's okay in the UK, but not in Brazil, that has all sorts of interesting implications for where people build and use AI and where you can deploy models trained on copywritten material. If you have an AI-generated image like that Cosmopolitan magazine, which at the moment probably isn't protected in the US, but is protected in the UK, you have, again, a very interesting system where you only have IP protections in some jurisdictions. So WIPO has been leading a conversation on these issues. In theory, there may be a new international treaty on this at some point. In practice, that's a very slow process. And in the meantime, jurisdictions in the past couple of years have, as cases have increasingly emerged on these issues, have started going in different directions. I'm going to speak a little bit about copyright and a little bit about patents, and we don't have that much time, and I know Carrie's is going to do more copyright. But in brief, AI making stuff isn't a new claim. There are always people involved in some way, but this is a Soviet mainframe from the 1960s that Soviet researchers said was making music. And if you haven't heard the earlier music, it's really very, very bad. You'd listen to it once for the novelty of a machine making something, and then you'd move off it. But OpenAI, you heard a bit about DALL-E 2, which has also an open jukebox initiative, has trained machine learning algorithms based on the music of popular artists, and it can make music that sounds like popular artists make it. And it used to sound unintelligible, and a couple of years ago, it sounded not very good, but vaguely like it had been made by these people. And now it is at the point where Equity UK, which is a performing actors union in Britain, has launched a campaign to stop AI stealing the show, because the use of AI to do this has become so very prevalent in music and movie industries. And they're not worried that the robots are going to take over exactly, but they are worried that music and movie studios are going to use AI to copy the likeness and style of artists and then not pay them what they believe would be fair remuneration for that. So these are not futuristic concerns that people are having. These are concerns that people are having right now. And of course, if you have an AI that makes Katy Perry-like music, that raises all sorts of really fascinating copyright issues and all sorts of socially and commercially interesting issues, especially if you get music that even sounds, as good or better than Katy Perry music. Plus, AI can make music in real time, even personalized to you, to go along with things you were watching or games you were playing or exercise routines that you were engaging in. And so it may change how creative works are made and used in some really interesting ways. Just a little bit of the law on this, because I know this has been a fixture of prior conferences here. The US currently has no case on this. They have a Copyright Office policy that says there's a human authorship requirement, which says if you don't have a traditional human author, you can't get copyright protection. And they cite in support of that policy to the 1884 case of Burrow-Giles v. Cerrone involving this famous photograph of Oscar Wilde. And it was a case where the Supreme Court held that a photograph was eligible for copyright protection, even though it is not literally the writing of an author. And they held that really any tangible expression by which an idea in the mind of an author was given form or was, given form is eligible for protection. And the Copyright Office says, well, that doesn't include machines, which don't have minds. There have been a couple cases on things kind of like AI-generated works. The leading one was a series of pictures taken by a monkey of itself. That case was ultimately dismissed, but based on the idea that animals couldn't bring lawsuits. And kind of amusingly enough, the court which tossed the case out and said animals can't bring lawsuits routinely hears lawsuits from animals because, of course, people are animals. So a lot of these concepts are linguistically confusing and philosophically confusing, not to mention legally confusing. Oh, and there's Naruto for anyone who wanted to see an adorable picture of the monkey, which took its own photograph. In the UK, the law is different. There's a statute that's been there since 1988, which says if a computer makes a work in the absence of a traditional human author, that work gets copyright protection. The UK IPO, in its recent consultation, essentially decided not to mess with that. There's been very little litigation on it for a few reasons. One is there isn't a lot of copyright litigation on subsistence of copyright in the UK, period. Second, even if you thought someone had a Katy Perry better like AI, there wouldn't be a lot of point to suing over the existence of copyright because the law makes it clear that there is copyright. But I think most importantly, up until really now, these works haven't had much commercial value. So who's going to sue over them? Well, me, I suppose. So as part of the Artificial Inventor Project, which I'm going to get to, the name has now become a bit misleading. There's now also copyright involved. We filed a copyright registration for an AI generated work. It's this image you see below. The Copyright Office decided not to register it. We filed a lawsuit in the district court in the DC circuit, and we are waiting. We are in the process of filing motions for summary judgment at the court. Not much has happened in this case yet. But again, the Copyright Office's position is if an AI makes a creative work, it cannot get copyright protection. We argue that this work should get copyright protection. And the reason for that is that the US Supreme Court has said on a number of occasions, while there are a lot of policy benefits possible from copyright, the reason we have it in the United States is to serve the public interest in promoting the generation and dissemination of works. And if that's the outcome you want, then that's an outcome you get with this, because of course the machines don't care about copyright, but OpenAI charges money to have people generate works. It's a complicated business model, in part because of the lack of copyright and a lot of legal uncertainty. At the moment, they charge people for computing cycles over a certain number, and then they license them the right to the work. But if we're moving into an age where people will use AI to make creative works, then that's something copyright should encourage. If, on the other hand, you were a jurisdiction like France that very much believes copyright only exists to protect the human rights of human authors or the moral rights of human authors, then you might not want a system like that. The US, of course, though, allows companies to be authors and has allowed that for over a century. In our submission, we noted that the AI was the author because it was the factual author, but that doesn't mean it has any legal rights. It is a piece of property. And so our claim is that anything made by the property is owned by the owner of the property. The same way if you had a 3D printer make a physical painting for you, you would own that. So you should own a digital image made by your creative AI. I've totally lost track of time now, but I'll just try and hurry it up on principle anyway. On the patent front, you heard about from Chris, so I could probably skip over this a bit more. This was a case Siemens presented at the WIPO conversation, with the green thing being a car suspension and the silver thing being an AI design car suspension. And they decided they couldn't file for a patent on this because they couldn't find a human inventor. The engineers involved said it just came out of a machine. And so this at least is the pressing commercial problem. And this technology has moved very quickly. Large pharmaceutical companies, for example, have invested very heavily in this space in the past few years and are increasingly using AI to do drug discovery. And that isn't to say that every time someone uses an AI, you have an inventorship problem. Chris gave a few examples for how someone could be an inventor, finding a problem to be solved, but normally not that. Normally we know, well, we want a vaccine for COVID, we want a new car suspension, we want a better microchip, we just don't know how to design it. Sometimes programming an AI to solve a problem, but modernly, many companies are in the business of pre-training machine learning algorithms and licensing it to other people to use. And the people using the algorithms may be using them in ways that the people who program them may not know they're being used. So you might pre-train an AI to optimize industrial components, someone else may go off to use that to make a car suspension. Under US law, at least, if you didn't conceive of all the claims in a patent, or at least one claim in a patent, you can't be an inventor for it. So that probably wouldn't work under US law, although there's other jurisdictions it might work. Finally, recognizing the value of an AI's output might do it. And if an AI says, well, here's 10 car suspensions, go build them, test them, find the best one, that seems to make someone an inventor. But if an AI says, someone else built me, you asked me to find a new car suspension, I've made 10 million of them, I've tested them all, and here's the one that's clearly the best, hard to see anyone in there has made an inventive contribution, at least directly with respect to the inventive output. The AI itself gets different protections. So in part because there was a real lack of case law and clarity on this for stakeholders, and in part to promote a discussion on these issues, I lead a group of attorneys internationally in filing test cases on AI-generated inventions. We just printed a prototype of one of these inventions. This is a beverage container based on fractal geometry. I'm waiting for it to get shipped to me. They told me not to drink from it, but I am planning to drink from it. But a design like this could improve robotic grip or transportation or heat transfer, given the fractal geometry of the container. We filed for these patents in the UK and in Europe, and they underwent successfully preliminary substantive examination. We then corrected the inventorship to note that the inventor, in fact, was an AI, although the owner of any property rights in it would be the owner of the AI. Here's the PCT filing, and then we've now sent it out to 18 jurisdictions. South Africa granted us a patent last year with the AI listed as the inventor and the AI's owner as the owner of the patent. Again, this wasn't a matter of giving a machine any rights. The machine isn't a legal person. In point of fact, though, inventors often don't have any legal rights, and most patents are owned by artificial persons in the form of corporations. Australia, 3 days later, the enlightened Justice Beach wrote a 41-page reasoned decision as to why under Australian patent law, an AI could be an inventor, and at least in our case, we had the clearest claim of entitlement. 5 of his colleagues reversed that decision several months ago. The Australian High Court is now deciding this month whether to take an appeal. In the UK, we had a split decision by the UK Court of Appeal. Justice Burst thought we ought to have gotten a patent. Justices Arnold and Liang disagreed with that. The Supreme Court in the UK has now agreed to hear the case. The hearing is tentatively scheduled for February of next year. And you heard from Chris that the Federal Circuit recently upheld the US Patent Office's denial of the applications. They just denied an en banc petition, so the next step in this would be a petition to the Supreme Court. The US and the UK Supreme Court, though, of course, take a very small number of cases, but we are planning to file a petition for that. And here the court basically said, well, an inventor is defined as an individual in the US Patent Act, and that could only be a natural person. And, it's a very interesting question. It does depend a lot on the text of a patent act in a particular jurisdiction, none of which were written for this in mind. But the first thing the Federal Circuit did was go to the dictionary and say, well, the dictionary says that an individual is a person. And if you go to the second definition in the dictionary, it says an individual is a thing. And the list in which you're found in a dictionary really isn't a decisive factor. So it is interesting, even textual analyses of these questions can be very complicated. There are some other things like an oath requirement, and I'd briefly hazard a guess at some of Chris's questions. An AI wouldn't do an oath or a declaration, but there are a number of instances in the Patent Act and the US PTO manual where inventors can't or won't do oaths, and still a patent has to list the correct inventor. An AI obviously wouldn't give a deposition, but that isn't to say that there wouldn't be depositions. You would just be deposing the people involved in making and using the AI. And it may be that an AI is actually a lot more transparent as a subject for this sort of thing than a human inventor, who have all sorts of reasons to lie about things or not remember things, whereas what an AI did may be fairly well documented in its records. I think I've forgotten all the other points I was going to make about that, so we better move on in the interest of time. Germany, however, said, sorry, this is Europe. Europe said, well, an inventor has to be a natural person, but the owner of an AI can list himself as the owner, as the inventor on that basis, just by owning it. And you can even state in the patent specification that this is an AI-generated invention. So they have come up with or proposed this workaround. We have a divisional filed in the case. We'll see the outcome of that. And a German court has said, well, again, for us, an inventor has to be a natural person, but we also don't have any of these US, UK-like rules on inventorship. If you just name the person with the closest nexus to the invention, that's adequate for us. And you could even write in the patent specification, it's an AI-generated invention. The German Patent Office didn't like that. They're appealing it to the Supreme Court. Although it doesn't solve, what might be for now the more practical challenging question of, well, if you have 1,000 people involved in making and using an AI, on what basis does someone have a close nexus? And Chris brought up the joint invention issue. As a practical matter, it won't matter so much if everyone's at Siemens. But if you have, for example, a collaboration between Microsoft and Novartis, and Microsoft is contributing an inventive AI, and Novartis is contributing a bunch of pharmacologists, it could have some real commercial implications. And I will end it there. Thank you.